I'm going to go ahead and start with our first presenter of the day. Natalie Stoll is born and raised in Morgantown. She helped the Stoll Seller Culpepper Legal Group, a full-service law firm located in Morgantown, and has been serving as a GAL Respondent, Counsel, Foster Parent Counsel, and Child Abuse and Neglect Proceedings for 21 years. Please welcome Natalie.
Good morning. Can you all hear me? If you cannot hear me clearly, wave and let me see you. Okay. Well, good morning on this very chilly morning. I'm so glad that we are here able to share some great information about abuse and neglect proceedings. And the thing that I'm going to be discussing this morning, the topic that we're going to cover, is going to be preliminary hearings and adjudications as a guardian ad litem. So we're going to look at what your role is, what the investigation is going to look like, what types of things you're going to be doing as a GAL targeted for those proceedings. But let me say just a few things first. I don't want this to be a situation where I'm just standing up here and talking to you for an hour. I really would like this to be a conversation between all of us. Whether you are brand new to being a guardian ad litem, or whether you've been doing it for 20 plus years, we all have some things that we can learn and that we can teach each other about being better GALs. So I really welcome questions and comments and suggestions as we're going through this. And I hope that you'll feel free to raise your hand. If you have experience to share, if you have a suggestion to share, please do that. And let's make it a conversation, not just a lecture. Second of all, if you do have questions, please go ahead and do interrupt. It's okay. Raise your hand and let's talk about it at that time. I think it's easier than trying to take questions all at the end. But if you do have something that you want to wait till the end, that's fine too. I'll try to make sure we have a couple of minutes where we're able to do that. So just so that I have an idea, how many folks in this room have at some point served already as a guardian ad litem? That is a lot of collective wisdom in this room, and that makes me happy to see. Thank you so much for your service. I appreciate you. And let's go ahead and talk together about preliminary hearings and adjudication and our role in those proceedings. So, as some of you are aware, at this point, we really have a dual role as guardian ad litem. One hat we wear is as attorney for the child. And that comes with all of the same obligations and duties that we have when we represent any client. But we also wear another hat. And that second hat is the one where we represent the best interest of the child. And yeah, sometimes those can come into conflict. Sometimes we have to think about which hat we're wearing at which time. But we have to keep in mind that as GAL, we don't just go one direction or the other. We have to balance those. We have very broad discretion in terms of figuring out what's necessary to protect the best interests of the children we represent. When we have a competent adult, it's presumed that they know or can tell us what they think is in our best interest, but not so much with a child. So we have to really give some thought to that, and we've got a lot of discretion in figuring that out. So the safety and well-being and timely permanent placement of a child, those are going to be central to our representation of that child. So in that aspect, it's very different than representing adults. We have a duty to represent them at every stage of the proceeding. For those of you who have been doing this for a while, I'm sure you're aware that there's Supreme Court authority that says very clearly we have a duty to represent at every stage of the proceedings. And that means through appeals. That means if we have motion practice. That means after disposition. That means every single stage of the proceeding. Now, early on, I think there were some questions about that. Do you represent during an appeal? Well, the Supreme Court's been very clear, yes, you do. So until your child is in a safe, permanent placement, and all proceedings have ceased, and the case is off the docket, you are still representing that child, and all of the duties still attach to them. We are required to provide competent representation, and that's one of the reasons that we do these trainings, so that we understand some of the differences and the additional obligations we have as a GAL. We are also, as with any client, we're required to provide that representation under our ethical rules with reasonable diligence and promptness. So that means that we have to be on top of things when these cases move really fast in terms of getting to know the child and investigating and making sure you're on top of everything that's happening in that case. We're also required to do a full and independent investigation. And we'll talk a little bit more about what that means later, but that's part of our duty. And based upon all of those things, then we make recommendations to the court. Now, we've gotten some very clear guidance as to what we need to do to be able to meet all of those obligations. And certainly this list is not the end-all and be-all. There are other Supreme Court cases that give us guidance on specific duties that we have. But by and large, you're going to find a really good checklist in Ray Jeffrey RL, and in Appendix A, Rule 18 refers to it, Appendix A of the Rules of Procedure for Child Abuse and Neglect Proceedings. And repeatedly, Supreme Court authority does then point to generally the rules of professional conduct, because they apply to children just like they would to representing adults. So if you look at these sources, you're going to see a laundry list of things that you need to consider, a checklist that you can go down, especially as a new GAL, and ask yourself, have I done these things? Have I done each of these? Have I diligently looked through this and met each of these obligations? So let's talk about what are you going to do before a preliminary hearing. So you got a case, what do I do now? The very first thing that you're going to need to do, obviously, is read the petition. But I say that a little bit tongue-in-cheek. You'd be surprised the number, at least early on, the number of attorneys that would come in and they're reading the petition right at the preliminary hearing before they walk in the door. You really need to have a good handle on what's in there ahead of time, because it's going to give you the factual allegations. It's going to give you who all the players are in this particular case. And it's going to give you an idea of what types of issues you may be looking at. Now, those issues may well change once you get into the case, and often they do change. Now, how many people here have started out with a case that looked like it was going to be a case involving parents and drug use? And as you get into it, all of a sudden there are all these mental health issues that pop up too. And, I mean, you see things like that all the time. So yes, the issues may change, but it's going to give you a starting point. So don't just skim it, really read it, make some notes about what are the issues, who are the people. It's also going to give you an idea in the who are the people column about who you're going to need to interview. Because you need to have in the back of your mind, yes, I have to do a full investigation. So who do I need to talk to make sure that I have as complete a picture as I can have going into the preliminary hearing? The initial order is going to do one of a couple of things. It's either going to grant temporary custody to the department on a finding of imminent danger, or it's going to grant temporary custody to somebody else in the department, to be potentially a responsible relative. It's going to set a preliminary hearing in those types of cases within 10 days of the filing of the petition. So it's going to tell you when and where. It's going to also appoint counsel. That's where you get your appointment order, which you're going to be relying on to get records and to be able to talk to people who otherwise wouldn't be able to communicate with you about sensitive types of information with this child. And it's going to provide for transferring the child physically to a responsible person or to the department. So all of those things are pieces of information that you need to know. Again, don't just skim it. You need to know who the players are and what's happening there. You may also appoint CASA. It's my dream to have CASA in every county that gets appointed on every case from the beginning, and that dream has not yet become a reality, but it would be terrific. How many people here have CASA that's active in their county? I'm so grateful for them, because they really add a component to these cases that is wonderful and helpful and informative. They have a lot of good sense. So sometimes the initial order can initiate services. I see that occasionally. I don't see it as often, but once in a while. And you're going to find, of course, the statutory language in those, the contrary to the welfare language and the reasonable efforts language. And that is going to attach to federal funding. It's necessary language so that these cases can go ahead and proceed, and we know that we're not going to have any issue with services down the road. Now, the initial orders that do not grant temporary custody, those are in common vernacular called 10-day orders in a lot of counties. Those are a little more rare. Who here has seen one of those animals? Most of them at preliminary hearings. Most of them are quick. But some of them go ahead, and in cases where there's not imminent danger, the petition is filed, and you get this order that does not actually transfer custody, but it does initiate the case. And in those cases, there may be a preliminary hearing set, but more often, it's going to go straight to setting an adjudicatory hearing within 30 days. And rather than having a preliminary hearing, because there's no issue of transferring the physical custody of a child and legal custody of a child, there's no imminent danger. Instead of having a preliminary hearing, there may be instead a pre-adjudicatory hearing conference just to make sure everybody's on the same page. It's kind of like a pretrial conference in civil cases. It's going to also appoint counsel, and it could provide for transfer of a child physically to a responsible person without transferring legal custody. Again, it may appoint CASA. If you're lucky, it appoints CASA. So those types of things you're going to find in the order. So I talked very briefly about the adjudicatory pre-hearing conference. There are some counties that I've never seen them do this. I've never seen them use this procedural mechanism. Other counties use it pretty widely. Is there anybody else here who has actually attended an adjudicatory pre-hearing conference? Okay. I see a couple of people. A couple of the counties, other than the northern part of the state, use these a little more liberally. This is very useful in cases where you don't have imminent danger, you've got an adjudication that's set, and you need to find out what the issues are, who the witnesses are going to be. Make sure that the initial discovery, that your Rule 10 discovery is timely exchanged, that you get an idea about how long the hearing is probably going to be. There are a lot of different issues that end up covered here. You also should look at whether or not the respondents have been served, which is a big deal in some of these cases. Because if the respondents have not been served and reasonable efforts haven't been made to serve them, then that's going to be a problem in this case. It may end up coming back. We've had some real doozies of cases with service in some of the counties where I practice. We've had, obviously you get out-of-state service issues, but we've had out-of-continent service issues, which kept coming back to haunt us. We were trying to figure out how to serve somebody. So, but any party can ask for a pre-adjudicatory hearing conference. So if your court doesn't set one, then you can ask for one. And that gives the court and all of the parties a chance to talk about all of these issues. And if you look at the initial petition, and if you look at the appointment order, and already in your mind you're seeing some red flags about evidentiary issues or service or witnesses, this is a really good mechanism to try and work all of these out early on, far in advance of adjudication, without everybody showing up the day of the adjudicatory hearing and not being prepared because these issues haven't been dealt with yet. I don't know about you, but there have been many times I've shown up to adjudication and we've had one of these issues, usually service being an issue, but occasionally witnesses, occasionally discovery. We've had these issues require that the adjudication be continued. Anybody else have that experience? And that can be really frustrating. And it's certainly not in the best interest of your client, the child, to continue an adjudication hearing just because something that could have been worked out pre-trial wasn't. So definitely, if your county that you're working in does not provide this as a mechanism, to deal with these issues ahead of time and request it. It also can be useful to the early investigation of the case, because with all of the parties and all of the attorneys in the same place at the same time, at an early time, in advance of adjudication, and at a non-adversarial proceeding within this entire case. It's not adversarial in the same sense that a preliminary hearing is. This gives everybody an opportunity to exchange information, and that can be really helpful. So let's talk a little bit about the investigation that you're going to need to be doing as a GAL. And I'm going to be walking back and forth a little bit. Can everybody see me if I'm over here on this side? All right. So let's talk about that investigation that you're going to need to be doing. The investigation is going to be an ongoing process. It is not just a one-time prior to adjudication, let's look into things. But it's going to be an ongoing process. And so when I talk about doing this investigation, I'm going to talk about this in stages, but keep in mind that it's really a continuous thing. It's not a bunch of little events. It's a continuum. And you need to tailor that investigation to the circumstances. As we get a little further, you're going to see lists of people that I suggest you can talk to in a case. But you don't need to talk to all of those people in all of those roles in every case, because the issues are different from case to case. So you have a really short time between the filing of the petition and the preliminary hearing. You need to use that time wisely and prioritize the things you're going to investigate. It would be great if you could conduct a full and entire investigation of the entire case and talk to all the witnesses and review all of the records, including medical or psychological records, in 10 days. But I don't think it's possible to do that. You have to tailor your investigation. You have to prioritize what's most important for the preliminary hearing, and then you build on that as you get ready for adjudication. So what kinds of things are you going to review? You're certainly going to review any court summaries, or they may be called different names in different parts of the state, different counties, but court summaries or attachments or memoranda or whatever information is provided to you, and the court summaries are provided to the court by the department. They're going to give you a really good starting place as to what you need to know about this case. There's going to be Rule 10 disclosure that should also be provided, and that's going to give you more information. Don't presume that the Rule 10 disclosure is going to be the same as what you see in the court summary, because sometimes it is, and sometimes it isn't, because as you are continuing your investigation, the department is continuing theirs as well. So there may be more information as time goes on. You also want to take a look at answers that are filed by the respondent. You're not required to file one for the child, although I see that many attorneys do file one, and that's fine, but you're not required to do that. The respondents are supposed to file answers. If they don't, then the consequence is nothing. There's no consequence if they don't file it, because the petition can't be taken as confessed if they don't file it. But in a perfect world, they do file it to give you an idea of what their perspective is. And sometimes that can be very instructive. How many in here have received a respondent's answer that surprised you, because in that answer they're saying, yes, I've got these issues and I really need to deal with these. And you're thinking you're going to be going to adjudication and really have to sort of battle it out and help the court understand what's going on, whereas the parents are coming in and saying, yes, we need to deal with this. I know I've seen that, and there have been times I've been surprised by it. Don't just get them and file them as another piece of paper in your file. Look and see what they're fighting about, what they're not, what they agree to and what they don't. Definitely contact the caseworker. Open up some type of dialogue with them, and that's going to be a dialogue that should continue throughout the entire case, because you should be able to update each other. So talk with the caseworker, find out what information they have. Also find out if there are other caseworkers that have worked on prior cases with the same family, and see if they can give you some more background. Sometimes they can. There are prior court files that may or may not be child abuse neglect files that also would be very useful. Some things that we will routinely try to review would be files relating to domestic violence proceedings, criminal proceedings, family court proceedings. All of these things may have and probably do have a bearing on what's going to be happening in your case. So when you can get them early on, you should. And certainly by the time you have your first hearing before the court, you can make the request for those. Social media actually can provide you with a little bit of insight too. And be careful about your ethical obligations. You can't log on and say that you're their long lost cousin. Will they friend you and tell you everything? You can't do things like that. But anything that's public may provide information. It may give you an idea about workplaces or schools. It may provide you information about other family members that you may be able to contact and interview. So there are some very legitimate reasons to look at public social media pages and get information that can help you further your investigation. And there may be other relevant records. I can't possibly list every kind because it's going to depend on the type of case. You're definitely going to want to interview the child. And I cannot stress how important this is. Even if the child is very, very young, you need to go and have eyes on this child and talk to the child. This may be a 4-year-old that doesn't really understand what's happening, but that child, in what they say to you and how they say it, in their body language, in the way they respond to their caregivers, they are telling you so much information in a way that is not the way that we're used to gathering it. And let's face it, we're used to dealing with adult clients, where we ask them a question and they give us an answer. Kids, it's different. They may not give you that answer verbally, but they may give you a lot of answers non-verbally. Or they may tell you 4 stories, and somewhere woven in those 4 stories, you're going to get that piece of information that you really were looking for to help you understand what's happening. So you've got to interview the child. And you need to tailor that interview, obviously, to their level of maturity. You're going to talk to a 16-year-old in a very different way than you're going to talk to a 6-year-old. The 6-year-old, with a 5-year-old, with a 4-year-old, those are the kinds that you're sitting on the floor playing a game and chatting with. And you can have some more direct conversations, very limited, short duration. They're not going to have the understanding. They're not going to have the attention span. You can have very close to an adult conversation with 16 and 17-year-olds who are going to really have a lot of insight into what's happening most of the time. So make sure they know who you are. Introduce yourself, not just your name, but help them understand who you are and what you do. I had an interview with some kids just yesterday, actually, and part of that conversation was, they were kids of several different ages, a whole sibling group. Part of that conversation was, what is a lawyer? What do I do? When I say that I'm your lawyer and I'm your guardian ad litem, those are big words. What does that mean to them? When I say I make recommendations to a judge, maybe the starting point is, well, what is a judge and what do they do? So you need to make sure that they understand, step back, understand who you are and what you do. And that can take a while. Sometimes that can take a couple of conversations. You want to try and get to know them. This is not just about getting information from them about the case or about the topic that you come to talk to them about. It's also about getting to know them. The better you know your child client, the better you can make recommendations about what's in their best interest, and the better you can try to work to fulfill their needs. You want to make sure that the child understands, to the extent possible, given their age and maturity, what types of decisions the court's going to be making. And sometimes that can be a really difficult conversation to have with a kid. So, has anybody in here had the opportunity to talk with an older child, especially, about the types of decisions a court might make, including decisions to terminate rights? If you've been a GAL, you've probably had that conversation, unless you've had all 2-year-old clients. And that, would you agree, sometimes it's a really hard conversation. It's a serious conversation. And they're dealing with adult concepts, even though you're presenting them in a way that they can understand. So you want to make sure that you know them well enough to help them understand what is a judge, and what are these decisions that are going to be made, and how does the judge make those decisions. And the fact that I don't make the decision, even though I make recommendations, and their mom and dad doesn't make the decision, and the caseworker doesn't make the decision. The judge makes the decision after hearing what we all have to say. That's a really important concept for them to understand.
Ma'am, I
Yes.
have something to add to that.
Yes, please.
Recently, I had the pleasure of representing a 17-year-old. And first I had the conversation with her as to potentially what could happen. And it was pretty sure it was going to be a termination case. And we had the oral conversation. She also had a 13-year-old sister who I did not put that obligation on. I still had the sense, not even though she was close, but what I asked this child to do after she had told me what she thought needed to be done was to write me a letter explaining her reason. And Monday or Tuesday of this week, that letter was entered into the record.
That is a wonderful idea.
Fortunately, the parents relinquished, and they were out of the courtroom when that letter went in. So they don't know what's in that letter, but the judge does. And what you see as a guardian is how this child you've watched for the last year gives you that letter after they've had time to really think about it after you've explained it. And the judge did exactly what this child wanted.
In the right kind of case, I think that is a wonderful idea. When you have a child, an older child, with that level of maturity, that to me seems to give them control over their recommendations. It gives them, you say power, and that's exactly right. They can't make the final decision, but it gives them the power to have their voice heard in a way that they need. And I think that's a great idea in the right kind of circumstances. So, any other thoughts on that? All right, so when you are conducting these interviews with the kids, please, please, please do not start conducting forensic interviews, because that's not our role. And that's just not going to help anybody, honestly. Now, if a child wants to talk to you about things that have happened to them, if they want to start making disclosures, do provide a safe haven for that. Be an active listener. If they want to talk to you about the things that have happened to them, then you can do them a real service by letting them talk to you and feel safe in talking to you about that. But don't try to get targeted information. That's not your role, and that's not going to help the child. You want to make sure that they feel safe, not just to talk to you about disclosures, but about anything that's going on. We have incredible foster homes in the state and very loving, giving foster parents. But sometimes there are things that happen in placements that are not positive. And if the child that you represent doesn't feel safe talking to you about what's going on currently, then there are times when that information doesn't come to light until much later than it should. And it doesn't have to mean something dire has happened. It could mean that something that they may feel like they are going to run away. They may feel that they're not having their needs met in some way. If they don't talk to you about that, or talk to some responsible, caring adult about that, a therapist or somebody else that can do something about it, they don't have a voice for that problem. So to the extent you can, get to know them and build that relationship of trust so that they can feel that they can talk to you. Okay. Now, along with that is going to come the idea of confidentiality, and I'm going to talk a little bit more about that later this afternoon in my session dealing with representing older youth. But when you have a child that understands, old enough to understand the confidentiality and the limits of that confidentiality, that can help build trust as well. If you let them know that, yes, there is confidentiality if they request it. And if they tell you something in confidence, that you won't share it unless you believe that they are placing themselves or being placed in some type of imminent harm situation. If you tell them that short of that you will be a person that they can tell things to and it'll remain in confidence, that can help build that trust. You want to try and meet with the child alone in a safe and comfortable setting, and that doesn't mean in their parents' living room, and it doesn't mean in the middle of the gym at school with chaos going around. Yeah, and sometimes circumstances aren't ideal, but try to find a safe environment where they feel comfortable. And it's okay with an older child, you can ask. We've got these 3 or 4 places of those places where would you feel most comfortable meeting. I've had some clients, older kids, some of them actually have asked to meet in my office because that astounded me too. I know, I see surprise back there. That astounded me too, but they felt that they could talk there in a way that they couldn't talk in the home where they were placed. There wasn't anything wrong there, they just didn't want to be overheard or felt like they were being overheard, and it was kind of close quarters. And that's okay. Some have wanted to talk in a private office at school, and that's okay too. You want to give them a chance to talk about themselves, ask about their family, open-ended questions, but ask about their family, ask about their current living situation. You can ask about whether they want to have contact with anybody that they're not currently seeing. And leave that kind of open. Usually I'll hear things like, yes, I miss my grandma, or yes, I want to see my aunt, or can I see my sister more? And sometimes they'll say no. But you've got to give them the power to tell you that and give you that information. You want to also find out if there's anything that they feel like they need from home, because often there is. They'll have left a favorite toy or some type of belonging that to them is a big deal. So kids don't really necessarily have a lot of things that are just theirs. And I think that's true of all kids, because adults hold the power over their use of their possessions. So having things that are theirs, that can be really important. And that can help them maintain a tie with home if that's what they want. So ask them, is there something they want from home? Is there something that's theirs that they want to have with them, if that's possible to do? You also want to make sure that they are aware of what's going on as the case is progressing. Again, you have to do that with an eye to their age and maturity level as to how much you disclose and how you disclose that. But you need to let them know how it's progressing generally. And always, always ask, if the child is old enough to understand this, is there anything you want me to tell the judge? Is there anything you want the court to know? And the next question beyond that is this okay if other people hear it too? Or is it something that you just want the judge to know at this point? And then you can deal with that issue as that comes up. But again, they should feel free to give their thoughts and their opinions and their feelings to the court, but they should feel safe doing that too. So you want to talk to current caregivers and foster parents. And has anybody else had the experience where they have talked with a foster parent for the first time and introduced yourselves and said, okay, I'm going to be guardian ad litem in this case. And the foster parent says, oh, thank goodness, I never heard from the guardian ad litem in the last case. Anybody else have that experience? And together, we as a group, we can stop that. It's really important that that experience be a thing of the past, because we as a group know that we're going to be able to make contact with these caregivers and how important that is. And so I want them to feel that they have a line of communication with us. Not only do we need the information they can provide, but if they feel that they are not being supported in what they're doing, and that the child in their care is not being supported, then some of those foster parents don't stay foster parents very long. So not only is it bad for the child you represent, we lose foster parents through that process if we're not in good communication. Let them know what's going on. Some of them are first-time or early foster parents. Yes, they have training, but go over the types of basics that they need to hear anyway, because a lot of that goes by pretty fast. And letting them know what your role is and what types of proceedings there are and what kinds of decisions the judge will make at each of those proceedings, that can be really helpful for them. It also helps to alert you when the child has questions about those proceedings that they ask the foster parent. Then they know what to come to you with and ask. You want to find out about current medical and psychological and other needs that the child may have. Make sure that those are being met. And also, you want to find out, and this is particularly in cases where it is a kinship placement, relative placement, that if the parents have attempted to contact and ask, hey, how's my child doing? That tells you a lot about the dynamic and whether or not the parents are going to be engaged in the process. You want to find out about behavioral issues, any other observations that are going to be made by a caregiver or a foster parent in that setting that may not be observed anywhere else. They can provide excellent information to you about that. You also want to find out what concerns they may have for the kids. They may have concerns that are based upon a whole bunch of observations that alone would not be all that meaningful, but they've raised some red flags. Ask what their concerns are and make sure that they actually have notice of the proceedings. They are required to get notice. Make sure that they have notice. You are going to be probably one of the best conduits of information. The caseworker should be in contact with them, obviously, as well, and giving them notice and explaining to them where we are in the proceedings. But they will often turn to you. So make sure to go ahead and provide that information to them. You definitely want to talk to potential relative placements or kinship placements and be asking that question. Reach out to Respondent's counsel and say, hey, have you met with your client yet? Do they know of any relatives that might serve as placement? What information can we get? And yes, the caseworker is doing this as well. But you should reach out, you should ask the question. See if there's anybody out there that may be able to serve as a kinship or relative placement. You also have an opportunity, whether or not they ever serve as placement, to get information about the family from them. Sometimes information about family dynamics that's provided through a potential relative placement can be very helpful in figuring out what services the family needs and what the child needs. So use that source of information.
I have a question on that.
Yes.
You said the caseworker will be trying to find relative placements. Are they doing that in Morgantown?
They are largely doing that in Morgantown. Yes.
Most of the petitions I've seen, they don't even bother to fill that section out in the petition.
And unfortunately, I think your experience is a common one. What is your experience generally in the room? Do you all feel that, how many of you feel that relative placements are being explored early on in the proceedings? How many of you feel that relative placements are not explored almost at all unless you push it? So it's about half and half. So that's unfortunately a fairly common experience. What I can say is in my experience, things are getting better. They are federally mandated to seek relative placements. They're required to look for them. And to the extent that they do or don't, I see things all across the board, but generally getting better. I would suggest that in your role as GAL, you can try to help push that too. And bring it up, ask at the preliminary hearing, what measures have you taken? Make sure that you open up a dialogue with them before the preliminary hearing and say, how can I help you find potential relative placements because it's in the best interest of the child. So I'm glad that you're on top of it and sharing that experience, and hopefully we can, again, collectively try and improve that situation some. So, question?
Yes. So I live in on a border county where we have a number of relative placements that may be out of state. So the issue that we have is with the ICPC, and some of the surrounding states are not as cooperative as perhaps they should be. The department's position is that they can't place those children out of state without the cooperation of the departments in the other jurisdictions. So many times we're looking at 6 months before we finally get something from a foreign jurisdiction. How do you deal with that with a child who's in foster or in some other placement, especially a very young one?
I wish that I had a really good, quick answer, but I can tell you that's something that we've been struggling with statewide for years and continue to struggle with it. And one of the things that we have used in some counties where it's feasible to do it, at least for if it's a relative placement and it's across in a neighboring state, is we've had judges order that the guardian ad litem go and do a home visit, do an investigation, report back to the court, and the judge will sometimes then go ahead and order placement while the ICPC paperwork and process are catching up. And it's not a perfect solution, but it's worked in a great number of cases where this issue has come up in the counties where I practice. So,
That is not a violation, that's the court violating the federal requirements.
to have a guardian ad litem go and check it out?
To have a placement outside of the jurisdiction.
Not necessarily. I can tell you that it's happening. So whether or not it should be, I can tell you that it's happening.
The department objects to the placement on the record.
In many cases they do. They're supposed to.
Yes.
In some cases, they just don't say much of anything about it. They're supposed to object on the record, and the judge understands the reason for their objection. And in the counties where this is happening, the judge is just going ahead and doing it anyway. So,
Can't the other state then reject the ICPC because you sent the kid over without the ICPC?
I'm sure that they could. I have yet to have it happen in one of the cases that I'm working in, but that doesn't mean that it couldn't. Doesn't mean that it couldn't. So, and that's certainly something that you're going to want to consider. The states, the surrounding states are kind of all over the place with it. Some are very cooperative, some are not cooperative. So I think you need to take into account the level of cooperation you're getting, whether or not that's been an issue in previous cases. There are a lot of things that you have to take into account, but you also have to take into account the child's need to be with a relative caregiver, and it's a balance. It's definitely going to be a case-by-case kind of analysis. So, yes?
I don't know if anybody else is experiencing this, but up in the northern panhandle, we've had such an issue with staffing at the department. I can't get my ICPCs even started, let alone done. I have 2 cases that I have permanency issues with that I can't, they told me months ago these things were done, and then I come to find out 3 months later, they didn't even start them. And it's not something I can do. But meanwhile, the kids are suffering because they're in, placement with foster families, bonding, and then they're going to have to rebond back with these other family members that are being considered for placement. It's causing issues.
That's a good point. Were you all able to hear that over here? Okay. What she was expressing is that in the area where she's practicing, there are staffing issues that are preventing the ICPC process from even getting started. So from the time that it's requested, there are months down the road before even the initial paperwork is complete. It's taking a very, very long time for that to happen. And certainly there are counties where that is a huge issue. And I see another question over here, which may have been a comment about that as well.
I was just going to respond to that because we have the same issue. And so what I've had to do in those situations is I file a Regulation 7 ICPC expedited order with the court, outlining the process for that, and then I track that process through the compact administrator in Charleston, then whatever the foreign jurisdiction. I mean, you're basically doing a lot of the job of the department, but if it's a critical issue and the child is, in limbo, that is the only thing you can do. Then you have the ability to file a motion for a rule to show cause if it's not being processed, and our courts have even requested at times that the compact administrator be contacted to participate in that rule to show cause.
And that is a good solution. Are you getting substantial compliance with it when you go the route of filing the order and micromanaging each step?
When I do that, yes. that when I make future requests. Sometimes it's taken a little bit more seriously. But because of the turnover with the department, you're training new department workers each time you have a new person.
Sure. So was everybody able to hear that, or? No, okay. What she was suggesting was, the way that she has dealt with this, is that she essentially will file an order to get the process started, micromanages it every step of the way, which is not ideal. In terms of you having to do that, it's not ideal. However, it does ensure that the court has eyes on every step of the process as well. And if there are undue delays in that process, then the court can step in and intervene. And that may be what has to happen to make sure that we're able to get everything done within some reasonable time frame for cases that are going to require an ICPC placement. So I appreciate that information, and that's good to know. Does anybody else have any? Yes, in the back.
So I suggest that you put in the record in your hearing that by not following that protocol and trying to circumvent it, you are affecting the rights of another state. And if you understand the reasons for the necessity of the ICPC, it is that state agreeing to become responsible for that child financially. And if you can educate your judge, make the motion yourself as a guardian, and insist on an ICPC before you move a child out of state. And where I fight it the most is when you have a natural father that maybe lives in Washington State, and they're trying to immediately shed this child off on a natural parent who maybe hasn't seen this child ever. Mm-hmm. And yet you've got the potential that this man allegedly has done offending early on. Now I have a theory, if you're that far away and you don't know anything about your child, you're not unoffending, but there are ways you can do it. One of them is to bring the motion for an ICPC relative to a specific home.
And so for those of you who may not have heard, what she was suggesting is you can also bring a motion for an ICPC relative to a specific home. And I think that the takeaway from all of this is that our collective wisdom here is that if you know this is going to be an issue, you want to get the court involved as early as possible. You want the court ordering that this must occur and that it must occur with some great speed. And sometimes you're going to have to micromanage that process all the way through. And I think, again, our collective wisdom is very helpful there. If you have had a good or positive experience getting this to happen, then by all means, share that information with the other attorneys in your area, because collectively, this information can spread, and perhaps we can be able to tackle this a little better than we've been able to tackle it in the past. With staffing issues that are not going to go away anytime soon with the department, we all know that they've got more cases than anybody could be expected to handle. This is going to be an ongoing problem, and so this is a good idea for a solution going forward. So there are other things you're going to want to see with your own eyes with regard to your ongoing investigation. You certainly want to see your client, the child, with your own eyes, even if they're very, very young, and preferably in their current placement, if they're old enough, in school, in a couple of different settings. You certainly want to have eyes on the respondent parents. Has anybody else here had the experience where you've got parents with a drug use issue, and as soon as they walk into the MDT, your first thought is, oh no, they're using again? Anybody else had that experience? And sometimes being able to see that they just don't look good, they just don't really seem to be with it today, that can be useful information to have in terms of fashioning something that's going to be helpful for the case and ultimately helpful for your client. You want to be able to see caretakers, the child's home, the child's school or daycare, get an idea with your own eyes on about these places and these people so you have firsthand knowledge about them as you're going forward to make recommendations. What information is going to be a priority as you're going into your preliminary hearing? The child's status is going to be a priority. The judge is going to want to know what is the current status. You're going to need to know what is the current status in terms of are their needs being met, do they have educational stability, have they been yanked out to a different school, what's happening with that. They're going to want to know whether or not they are maintaining contact with family members or other adults that are important in their lives. So have a good handle on that before you walk into a preliminary hearing. You also want to have a good handle on what evidence there is, if any, that supports a finding or refutes a finding of imminent danger. Just because imminent danger is not something that a court may find doesn't mean the case ends. But you certainly want to know whether or not there's evidence that supports or refutes it before you walk in. Yes, question?
When you say very young, how young is it? And the reason I ask, we got a lot of drug-affected babies, so take them at a day or 2 days, send them to WVU and the neonatal. The preliminary hearing to be 8 days old. You think that as a guardian, I should go down there and bother WVU while they're at that point, less than
If it's
2 weeks?
And the question is, if you've got a brand new infant, do you need to go and see that brand new infant who's just days old at the time of the preliminary hearing? And so my answer to that is ideally, yes. I think that is a good idea to do that if you can. You certainly need to do it before adjudication, but ideally, yes. Because if you have eyes on that baby, you get an idea of if they are normal or undersized, if they look healthy, don't look healthy, you get an idea about this new life, about this person. And they're not going to be able to communicate anything to you other than what they communicate non-verbally. But those of us who have seen a lot of babies, you can tell a lot of things by a baby, even a couple of days or a couple of weeks old, if you just look at them. And if you can hold them, or just interact with them in some way, you can tell a lot of things about their status, about their health. So ideally, yes. And I say that with the knowledge that everybody in here is busy, right? I mean, is there anybody in here who's looking for extra things to do because you don't have enough? No? I didn't think so. So you have to prioritize that. And if your priority is talking with the medical personnel and your priority is talking with grandma who knew what was going on in the household prior to the case being brought, and you don't have a chance to have eyes on that child until 2 days after the preliminary hearing, then those things happen, we understand it, we get it. But in a perfect world, if you have the time to do it before the preliminary hearing, yeah, I think you should. So you want to look at efforts the department has already engaged in at this point. Some cases, brand new, the department's not really been that involved with the family. Other cases, you guys may have had this experience too, where the department is working with a family that they've been working with for the past 3 years, trying to put services in place, but they just were spinning their wheels and finally brought a petition. Anybody else have that experience? Well, it's important to know, walking into the preliminary hearing, which of those animals you're looking at. Because it's going to tell you a lot of information about what you're going to need to know going forward. Also, know about the existence, again, of appropriate relatives or anybody who could serve as a kinship placement. If you have that information, bring it with you to the preliminary hearing. Here's some guidance from NRA Jeffrey R.L., and this is directly out of the list that the Supreme Court gave in that case. It's just important to know that this is what the Supreme Court prioritizes, much of which we've already talked about. So the purpose of the preliminary hearing, and I'm going to move along a little faster because we're running out of time here. So the purpose of the preliminary hearing is going to be to see whether or not, if it's an imminent danger case, whether there's imminent danger. Of course, you're going to look to whether or not a removal of a child in placement is something that was warranted, is going to be ratified, is going to continue. And you're going to look at whether or not there was probable cause to believe that there was abuse or neglect. So with regard to those, you want to keep those in mind as you're going into the preliminary hearing, armed with this investigative information that you have. And at that stage, you are indeed an advocate for the child. So you're going to do all the same things that you would do in a proceeding where you represent an adult. You're going to fully litigate the case to the extent that it needs to be litigated. You're going to compromise where it's appropriate to compromise. You're going to call witnesses. You're going to cross-examine witnesses. You're going to make legal arguments. There's no difference in your duty to this child as advocate than there is to your duty as to any adult that you represent. But you also have to provide the court with additional information. You've got an additional service, including providing the current status of the child and making recommendations. And those recommendations you need to make need to encompass things like the removal and placement of the child, visitation recommendations, services that the child may need. And those are types of things that you're going to know a lot more about after you've met with your child and met with the caregivers, met with the family. Then you're going to be armed with the information to make those types of recommendations. Keep in mind, too, if paternity is an issue, then make sure to make the request for paternity testing early. Sometimes it takes a while. Now, prior to adjudication, your investigative role is going to be ongoing. Doesn't end. Remember, not events, one long continuum of investigation. And you've got a duty to update your information. So what else are you going to look at in addition to what you've already reviewed? Well, you're going to look at any new evidence that has come to light, whether it be totally new or just new to you. You've just discovered it. You want to make sure that you also have a chance to look at medical, therapy, service provider records. Many of those things you're not going to have a lot of access to at the preliminary hearing stage because there's just not enough time to get them. But by adjudication, you should have enough time to be able to acquire things like medical records, to acquire therapy records if they exist at that point. You're going to definitely want to get updates from service providers, including service providers who have supervised visitation. Now, you're probably not going to have a whole bunch of visitations prior to adjudication, right? You may have only a couple. But even getting information from providers about those couple of visitations can be very useful. So talk to those providers ahead of time and find out what you can. Now, are you going to be able to use information about visitation in terms of proving or disproving the allegations in the petition? No. No, that's not information or a status or an event or other evidence that existed prior to the filing of the petition. But you are going to be able to use that information to make recommendations going forward. And when you're considering whether or not improvement periods are warranted or a good idea or in the best interest of your client. So you want to have that information going into adjudication for reasons not strictly because of the litigation aspect. Also, if you are working with foster parents who are keeping a log or a diary of their experiences with the child, and they really are trained to do that, and many do, it's really useful sometimes to see if they'll share some of that information with you. Has anybody here ever gotten those logs from or the diaries from the foster parent providers? I think it can be really useful and really helpful. You want to make sure to update with the department workers, anybody previously or currently involved with the family. You want to talk with the parents to the extent that you're able to do that. Keep in mind that you need to be aware of their counsel. And in the best of all worlds, see if their counsel will permit them to sit down and talk with you ahead of time, with their counsel present. It's a good idea to talk with older children, siblings, or other children who may have lived with your client or played an important role in your client's life. Talk to other relatives, hospital personnel, therapists. The list can go on and on and on. Are you going to talk to all of these people in every single case? No, absolutely not. You have to look at the issues in your case and then you target your investigative efforts towards investigating those issues. So you're not going to need to talk to coaches or clergy in every case. You're going to need to talk to them in cases where it's relevant. Also, the first MDT, which should be held prior to adjudication, needs to be held within that first 30 days. It's a good idea to be able to talk to everybody, just simply talk, and find out what information that all of the members of the MDT can provide that may be useful, not just in preparing for the litigation aspect, but talk about what services may need to be in place. What needs does your client have that their parents can share with you? Make sure that their medical needs are met, their psychological needs are met, their educational needs are met. So all of that information is going to be very useful in the first MDT. Yes?
I have found that when you go to MDT meetings, often all of the people that we really need to talk to are not there. So what I do is I require a representative from all facets of education, speech, hearing, whatever, to be at the first MDT, and that way they can't pass the buck to someone who's not there. In other words, if this child's got a hearing problem, I can go right over here and talk to this person. Otherwise, it tends to get slipped through the cracks and the services aren't provided.
I think that's a great idea. What she suggested was at the first MDT, she requires that there be a representative from all facets present there. So if there is, there's an educational plan in place, if there's a speech therapist, if there are therapists that are involved, somebody has to be there so that there's a more full picture from everybody about what the child's needs are and how to meet them, and about the family's needs and how to meet them. And I think that's an excellent idea. Attendance at MDTs is tricky anyway, but we're doing a lot of people phoning in when they can't be there, which is really helping some. Do you all have any experiences in terms of getting folks to be at MDTs so that they can be meaningful? Is anybody seeing this as a problem still, getting people there? So, to the extent that it helps, in the counties where I'm practicing, we're doing a lot of phone-in, which is, again, not ideal, but certainly is better than not appearing. And schedules can be a little tricky, especially when you have judges scheduling abuse and neglect hearings at the time you have MDTs for other cases. Yes?
I have a question. I have some defense counsel who will never let me talk to their clients. And so I'm wondering how, if I know that this is just how their defense counsel operates, do you have any suggestions? Or, because I've always said, if you'd like to be present with your client, I'll meet you in the office, I'll meet them in their office, whatever it is that they'll just say no. How should we weigh that or assess that if we're trying to make a recommendation about the parent's willingness when I'm not sure if it's the parent or counsel?
That's a great question. And the question over here, the observation in question, is that there are certain respondents' attorneys who will never allow the guardian ad litem access to their clients. That's just their policy, they don't allow it. And so how do we get around that? The way that I have at least worked around that, and it's not perfect, and I would love to hear the collective wisdom of the room. Sometimes I will prepare a list of questions and make sure that at the MDT, I'll say there's certain information I really need to get about the family. You don't have to answer this, but can you answer these questions? And sometimes in the MDT context, with their counsel present, I can get that information, sometimes not. There's also the possibility of giving them written questions just to see if they will answer some, and they can choose what to answer or not. There's no perfect way to get that information outside the context of the courtroom because they can refuse to talk to you. And you weigh that with however you deem that appropriate. There's always, of course, the opportunity to call them as witnesses in the next proceeding if you really feel that you need the information and it would be useful. And there are many times when we call respondents as witnesses to provide information about what happened. Does anybody else have any suggestions on how they have gotten around that particular issue? Oh, yes.
I've done the same thing you've done in MDTs, except the situation that I have is basically, I don't think that the respondent really minds talking. It's just a proprietary thing on behalf of the counsel. And so I basically kind of present it to the rest of the MDT like, I would really like to be able to have input from Respondent X, but unfortunately I'm not, being permitted to talk with Respondent X, so I'm just going to have to present the information that I have. And, I don't think the judge is going to get a full picture, but typically if I lay it out and the respondent is sitting there hearing that, okay, my voice is not going to be heard, my information is not going to be presented to the court, then I've had them talk to the counsel and say, what's going on? I want to talk to them. I want them to know.
So your experience has been within the MDT setting to go ahead and present the fact that they're not being permitted contact with you, and that allows them the freedom to...
In a nice way.
In a nice way. That allows them the freedom to be able to provide information to you. So, all right, so definitely also consider talking with CASA, who will be at the MDT, obviously, but CASA can provide a great perspective sometimes, which is very different than the perspective that attorneys are going to take on these cases. And I find that talking to them on an ongoing basis, not just reading their reports, but chatting with them about their impressions can be really useful. It is really, really, really important to have an MDT prior to adjudication. I know that you all are aware of that. We've talked about some of these. One of the things I want to highlight here is it also gives you an opportunity to discuss stipulations. You don't have to go into adjudication with guns blazing and ready to fight over everything. Very often, if you're not going to have an agreement as to the entire picture, sometimes you will have stipulations as to specific facts. And anything you can do to narrow the scope of the adjudicatory hearing is going to be of benefit to everybody. And to the extent that the parties can agree on services and the needs of the child, that's going to benefit your client tremendously. It's also important to consider at what point and how do you include a child in the MDT process. And again, I'll talk more about that later this afternoon in representing the older youth, but there are times when it is appropriate to have children at the MDT, particularly older children who want to be involved. But you do want to be careful about what stage and what will be discussed at the MDT and the maturity level of the child, and whether or not it's a better idea to bifurcate the MDT so that they can share their thoughts, concerns, feelings in a safer haven, and then have the parents in a separate MDT. So we can talk more about that later this afternoon, but those are thoughts with regard to the MDT and especially older kids. You also want to go in with an idea of whether or not you're going to recommend or not recommend an improvement period if one is requested. And I can't think of a case that I've had in the past several years where an improvement period hasn't been requested no matter what the allegations were. I think it's happening every single case all the time. So it's important to keep that in mind. Also, have an eye to whether or not it's a pre-adjudicatory improvement period type of case or not. Those are rare animals, but there are some cases that are amenable to that. This is the guidance from Jeffrey RL, and again, this sums up a lot of what we just talked about. If you haven't read the case, or if you haven't read the case in the past year, reread it. Very quickly, access to records. Keep in mind, you've got all of the power and authority that you would have representing an adult. If you need to subpoena records, subpoena them. If you need to subpoena witnesses, subpoena them. You've got a court order appointing you as guardian ad litem that will get you access to a great number of things. But if you are having a disagreement about a provider, which happens occasionally, in particular with mental health providers, they want their own special releases, and they want retinal scans and fingerprints from me, and you get a court order. And that just ends that problem right there. Go ahead and, in addition to the order appointing you, get a separate court order specifically for those records, and they will turn them over. The things you want to see with your own eyes prior to adjudication, this list looks a lot like the list prior to the preliminary hearing, but you're going to have a little more time. So where you had to prioritize these a little better before preliminary, you want to go ahead and make sure that you try and get eyes on this list before adjudication. Now, one quick word about reliance of department reports and CASA reports. The caseworkers are terrific. By and large, they do a really good job with very few resources. Most CASA are also terrific, but they are not omniscient. They're not going to know everything, and their information is based upon what they are told or what they find out. So you cannot rely on their reports as the beginning, middle, and end of your investigation. And you should always double check if it's something that's a critical fact to make sure that the information they were given by who knows what source was accurate. So don't use those or presume that those are going to be your whole investigation. Those are just one important component. Going into adjudication, you're going to need, again, to know the child's status, evidence that supports or refutes a finding of abuse and neglect, and you're going to want to think about not just whether an improvement period is a good idea, but what terms and conditions you want to have in that improvement period. And you want those set forth in the record. I really don't like seeing orders that just say, under the terms and conditions agreed to by the MDT. No. Have it in black and white what those terms and conditions are specifically, because that's going to help the respondents figure out what goals they have to meet and help you figure out whether or not they've met them. We talked briefly about pre-adjudicatory improvement periods. They're only 3 months, cannot be extended, use sparingly, because most serious issues cannot be addressed in that time. I can't even get clients into substance abuse treatment in less than a month these days. And so it's a really good idea to buy yourself some time at the front end. Don't think you can fit it all in if you can't. There are some cases that it makes sense to do a pre-adjudicatory improvement period. And when it does, then absolutely use it, but really think about your time frames. And these, again, are direction that the court has given us and the resources that I put up at the beginning of the presentation, which really sum up sort of what we've already talked about. The purposes and the legal standards with regard to the adjudicatory hearing, the court's going to determine whether there was abuse or neglect of these children. The legal standard is clear and convincing evidence, and this is going to be, unless you have a resolution that you've agreed on, a stipulation, this is going to be treated as any other litigation. So you're going to do all the same things in this type of a hearing that you would do in any other kind of litigation. The court has to make findings of fact and conclusions of law. Sometimes they're going to ask you to give them proposals for that. So have in mind, walking in, what your recommendations are going to be about that. And again, keep in mind that these findings and the court's ruling has to be based upon conditions that existed at the time the petition was filed. So although things that have happened since are certainly relevant to your child's life and your ongoing recommendations, they are not relevant to a finding of abuse or neglect. The guardian ad litem's role during this hearing is going to be as advocate for the child and to offer recommendations, as with every single stage in this entire process. Be prepared to do both. In preparation, you're going to go through discovery of evidence. You're going to review all of the things that we've already discussed, but you're going to update. Make sure that you're prepared to file motions, maintain records, and importantly, you need to make sure the court is aware of your client's wishes on an ongoing basis throughout this process. And the court's going to give more weight to the wishes of an older child than a younger child, but the court needs to be aware of that. Stipulated adjudications we've touched on a little bit, so I'm just going to flash this up here as we are out of time, but make sure that your stipulations, if you engage in them, are very specific, because later down the road, the question may come, did the services that the respondents engaged in, did they address the issues in the stipulation? And if the answer is no, then you have spun your wheels and wasted your client's time, which is very precious, especially for these very young children. 6 months is a lifetime in the life of a 5-year-old. So make sure that you are tailoring any stipulations and any services to fit together the way that they should. And again, be prepared to offer these same bits of information to the court at adjudication as with every stage in the proceeding. One last quick note about protecting the child from the investigative process. Please, please be aware of how many people are interviewing the child that you represent and the context in which that's happening. They should not be interviewed willy-nilly. If you have a child advocacy center available to you, use it rather than allowing 16 people to go and ask the same questions. And be sure to make sure that the respondents and caregivers and everybody involved are cautioned not to discuss the case or the allegations with the child. A therapist will know how to have that discussion. There'll be discussions you have with your client about it, but everybody involved should not be just discussing this case with your child. And again, these are guidance that were provided by the Supreme Court, which summarize pretty much the same idea. Make sure that you are protecting your child from the investigative process. Ask questions, verify, verify, verify. Make sure that you talk with everybody, stay in touch, stay up to date, update, and document what you learn. And that process is going to go on until you are no longer involved in the case and your child's in a permanent placement. So it is an ongoing process, and it's going to build. And I just want to say thank you all for what you do. I know that whether you are a first-time GAL or you've been doing it 25 years, I know that it takes a lot of work and a lot of emotional support and a lot of heart to be able to do these cases. And so I appreciate you all for what you do. And I hope that in the coming time that you will continue, as you have today, to share the collective wisdom of our group with other GALs who are working just as hard and who also may benefit from your wisdom. So thank you so much for all that you do.